We're going to, what I'd like to do is start by working the bill that we had the hearing on yesterday, 2448, used to be 2149. If you want to pull that out or pull it up on your computer. So does anyone have any discussion on that or amendments? If not, Representative Penn.
Would you like, did you do a motion on it, Madam?
We haven't.
Would you like me?
Mm-hmm.
Madam Chair, I move that we pass the bill out favorably for passage from committee. And
Okay, it's been moved by Representative Penn and seconded by Representative Owsley to pass House Bill 2448 favorably. Is there any further discussion? Representative Johnson, do you want an overview? Sorry.
Can I just look real quick? I haven't had a chance.
You can, and I forgot, I usually have Jesse just kind of go over it real quick. Like, Jesse, are you on?
Yes, Madam Chair.
Yeah, sorry, I usually have you do that, but you go ahead.
No worries. So House Bill 2448 was the bill that had the hearing yesterday, and this relates to the licensure of family foster homes. And so it permits the Secretary of DCF to allow family foster homes to be licensed while they have a former foster care youth that has juvenile adjudications that resides in that home. Without this exception, that in that instance, the family foster home would not be licensed under A2 of the current statute.
Okay, is that enough review? Does anybody have questions for Jesse? Okay, thanks, Jesse. So any further discussion? I know we've discussed this bill before and passed it out before, and I think we've taken out a lot of the concerns that we had on that bill. So Representative Wagoner.
Pardon me for not having all my notes from yesterday, but the bill we heard yesterday, it was slightly different than what we originally had. And so had we amended it or somebody else, or had it been
So that bill died at turnaround. And so that was the case where we learned of some of the repercussions and filed a new bill.
Okay.
So this is an exempt bill. It's the reason why we're able to work it now.
And the wording is different than the very first version we had of it, correct?
Yes, it was crafted more narrow. Do you want Jesse to go over that again?
Just, I mean, I have a version with me, but I'm thinking this must be the old version. That's what's confusing me.
Jesse, could you just go over the changes, what we had taken out of that?
Yes, certainly, Madam Chair. Thank you. So House Bill 2149 originally was a bill that gave the Secretary kind of this blanket discretion to make an exemption on these items that would prohibit all sorts of facilities from licensure. And that was amended in committee to narrow that down to more specific instances. And that was to be determined by an internal panel. And then that decision would then be given to the local county district, county or district attorney of, the secretary or this panel is allowing this person and this licensure. And so those are the two more broad instances of this statute that you saw earlier. And this bill 2448 specifically limits it to the secretary may make an exemption or may license a family where they have a former foster care youth that they've either adopted or is continuing to reside in that home. And that foster care youth has juvenile adjudications under A2. So it's very specific in the secretary can only make that exemption for those two specific instances of the child has either been adopted or continues to reside there. and they have these juvenile adjudications.
Thank you, Jesse. I think that takes care of it. Anybody have further questions on that? Okay. Then seeing none, we'll go back to Representative Penn. You want to close on your motion?
Chair, I close.
Okay. So it's been moved, seconded, and that we pass 2448 favorably for passage. All in favor say aye. Aye. Opposed, no. Okay, the bill is passed. The next item of business is I'd like to have a discussion on House Bill 2004. And I think it's been quite a while that you'll recall this was what we called Charlie's Law. And it's been quite a while since we had that hearing, and so I might ask Jessie if she could give us an overview of the bill again.
Yes, thank you, Madam Chair. Committee, House Bill 2004 is the bill that briefly codifies and creates an appeal option when there is an involuntary transfer or discharge of a resident in an assisted living facility. So going over more of what currently exists and what this bill does would be the subsection A, where it has the requirements for that involuntary transfer or discharge for adult care homes. That is in regulation. That's not in statute, but that is in regulation. And then when you get to subsection E, that's in federal regulations for nursing homes. So that nursing homes are covered by that federal regulation, but that part is neither in regulation or statute for adult care homes. So this bill puts into statute what is in regulation for assisted living, and then creates in statute that appeal process for that as well. And I'm open for any questions.
Committee, do you have questions? And I'd ask that you just limit those to the wording of the bill, if you have questions for Jessie. Representative Hoy.
Madam Chair, I'd like to offer an amendment unless there's other questions.
Representative Hoy, I just want to
Question?
have questions on it right now.
Absolutely.
Okay. Any other question? Any questions? Okay. So the reason I didn't want to do that just yet is I want to handle this one just a little differently. I want us to have a discussion as a committee on where we want to go with this bill. And we could work it, if you want to work it. I am aware that there's at least one amendment. I think we all are now. And if we would like to have some discussion on what that amendment might be, it would be up to the maker of the amendment to whether we want to present that yet, because I don't want to do it in the form of work in the bill. So if you want to hang on to it until we make that decision, that's fine. We've also had some discussion about referring it to the senior care task force that we have passed, a task force bill that we have passed out of this committee. It's not made it through the process yet. We have a strong feeling it will. The other side seems very supportive of it, but we have some wording that we could use to make that recommendation. We've also had some discussion of requesting a judicial council study. Is that what you would call it, Jared? A review. And that's been done before on other issues, and it takes a little bit of time, and then they come back with a non-political, non-partisan review and response to the issue and recommendation. So those are the thoughts that we have had in discussion between the three of us. And so I'd just like to hear, I'd like to have some discussion and hear some of your opinions on how you feel. Representative Penn.
Thank you, Madam Chair. If I recall the bill correctly, and thank you, Ms. Jessie, for reviewing that with us. I think this was the one that we had the widow of Mr. Charlie come in and speak with us. She had the picture. I think it's important enough of a bill for us to work and get through the process without any question marks as to whether or not it would be taken up by the task force, should it or should not be approved, as well as working in amendments. I don't know if my mic is working right now, but I would be in favor of working.
I'm having trouble hearing you.
Be in favor of working this now, madam.
Okay, thank you. Representative Helmer.
Thank you, Madam Chair. I'm in total agreement with what he said, so it would be worthless for me to repeat what he said. I think it's very worthwhile. Thank you, Madam Chair.
Representative Wagoner.
My recollection, Madam Chairman, was there was negative testimony against it, was there not? Or am I mistaken? I was thinking that somebody was speaking against it. And again, I don't have my notes here, but.
You know, I don't have mine either, but I do know that there is opposition from the assisted living facilities. And just kind of an overview of that is they are not staffed for like a nursing home facility is. And the bill actually states that the resident could stay living there until the appeal was made. So that's some of the opposition. I don't recall if there were, I remember a couple of assisted living facilities that spoke against it, or entities.
I was thinking Leading Age spoke against it, as my memory was, but I would be less favorable. I mean, I would think it's worthy of review. The question of the Judicial Council, what would they review about this bill? I mean, a Judicial Council, is there some legal question about it, or what would that accomplish?
Yeah, there would certainly be a legal question whether they, because there's liability issues about that resident staying there. The assisted living facility could be liable for a resident that they are not capable of caring for that level. Representative Owsley, that was one of your suggestions. Would you want to respond on the Judicial Council?
Sure, thank you, Madam Chair. I don't have my notes in front of me neither, but it seemed to me like it was a legal issue, the proponents or the opponents. I'm not even positive that they were in opposition or they were neutral. It's been some time. Okay, so the proponents and opponents, according to recollection, it seemed like a legal issue to me. So the Judicial Council would be one to look at that. And I agree with what's been said. It's important. There's no doubt it's important. And I would like to see some solution to it also, but I also want to get it right. And I'm just not positive that this committee has had enough information to get it right. Because if we kick it out of this committee and there's doubt, it could sit on the House calendar and go nowhere. Whereas if we, either ask for a review or, request it to the Oversight Committee or the task force, for further review, maybe they can dive into it and get more information, hold more hearings and get it right. That way, when it does come back to the House or the Senate, then the work's been done and it's been done proper. So I would just say that. I'll leave it to the wisdom of the committee.
Representative Esau.
Thank you, Madam Chair. I'm also recalling that there was something that the nursing homes were concerned that there might be unintended consequences if we passed it with the wording that it had. It might make, and I'm trying to find it and haven't found it yet, but I'd hate to see us pass out a bill that ends up getting messed up over in the Senate.
Representative Vaughn.
Thank you, Madam Chair. Just to build on the previous comment, I think remembering back, one of my primary concerns was just that if we ask the assisted living facility to retain a client that they do not feel they are able to care for, whether that puts that client at risk and potentially other clients in the assisted living facility at risk. So I want to make sure that we can, offer justice for families while also making sure that everybody is being properly cared for. So depending on amendments, I would be interested to see those in working this, but want to make sure that we're considering all those angles too. Thank you.
I might add that I know I've received emails, and I assume that you have as well, saying that this issue's been around for a while and has been studied enough. I will point out, though, that this is the committee that this is in front of now. And the fact that other people have studied this means nothing as far as our decision-making. We have passed, I've been very proud of all the legislation we have passed out of this committee this year that, what Representative Owsley said, that doing things right. We've cleaned up what we needed to clean up, and been very proud of the bills that have been below the line, and I've been able to make a case for. So that's why I've been hesitant here. I feel like the representatives that I have visited with have had some concerns, but also have concerns about the issue. And we realize there's an issue, but we are the body that is making the decision, not the ones who have studied it before. So we have to be confident in the information that we have. Any other comments? Representative Neighbor.
Thank you, Madam Chair. How long would it take to get a judicial review? Would it be ready for next session? Or if it went to the task force, which we don't know yet about, would they have time to review it and come before us next year? Because I don't think you want to go any farther than that. That would just be a question.
That's a very good question. I don't know the length of time that it would take for a judicial review. Do you, Representative Owsley?
Madam Chair, in the past, I don't have a lot of experience with the Judicial Council, but it does seem to get taken care of in the interim, so that things would be ready for next session.
Thank you. My concern was, if you put it out there for study and nobody does it before we're back again, then we've just lost all that time. So for me, if we had that time to get a deep look at by either one of those groups, that might provide us with more information, but I would hate for it to go beyond next year.
I would agree with that. And we could do both, for that matter. We make a formal request if we want the Judicial Council to take a look at it. Representative Penn.
And Madam Chair, that was my question. I'm unfamiliar, so please advise you or the ranking member or the vice. If we were to work this, add amendments to it or anything of that nature, would we be able to put a recommendation on there that it go to the task force and get that solid? Is there any space in that for the recommendation to go to one of those once we actually do our judgment on it here and ensure that it's taken up by one of those other groups as well? Can we marry the two is what I'm asking.
So you're asking if we could pass it out and do the other two, do all three?
Well, pass it out favorably with any amendments and make it as strong or as detailed as we care to, but also have that recommendation in the interim should the Senate not take it up, but we also send it over so it does get eyes on and has some activity happening should that matriculate with the task force or with the judicial review.
Well, I would just say that if it were the decision of the committee to pass out favorably, we would certainly follow through with the other two as well. So, Representative Owsley.
Thank you, Madam Chair. I was just going to say, I think we could open the hearing on it, amend it, and then we could not make the motion to pass it out favorably, but we could make the motion to table it for another day. That way it'd still be in committee and not on the House calendar. And then make the request for the review as amended.
Say that again.
Parliamentary procedure is not my strong suit.
So you're suggesting that we go ahead and begin working it?
I believe we could open the hearing, we could add the amendment, and then we could close the hearing without moving it out of committee.
Yeah, it wouldn't actually be a hearing, but working it. Okay. All right. Yeah. Okay, well, Representative Owsley.
Madam Chair, thank you. And then I also believe that if we can wordsmith this right, somebody told me that's actually a not a word, but I like it. If we wordsmith the request right, maybe we could request that it go to the Senior Care Task Force when established, and if not established, go ahead and put in the review for judicial council, or put in the request for judicial council review in case the Senior Care Task Force is not, doesn't make it across the finish line this session, to where we have kind of a safeguard.
I think I'd be interested in doing them both. Make the judicial council request anyway, even if it is, because the Senior Care Task Force could benefit from that. So the sooner on that, the better. Well, so if you are interested in working it, I'd entertain a motion to get the ball rolling, or, but I'm a little bit hesitant still, because I don't want to start working something that we are just wanting to pass out to sit. I want it to be something that we're comfortable with before we move it along past this. So just keep that in mind. Representative Owsley.
Thank you, Madam Chair. Well, before there's a motion made, maybe we could have discussion on the amendment so that we know what we're after.
Okay, so the way I work bills is to go ahead and start the discussion and have amendments presented, and then make the motion to pass it out. So with that, I'd recognize Representative Hoy.
Thank you, Madam Chair. Thank you for the good discussion. I think it is important to keep the discussion going, even if it needs some more work. And taking into consideration, I'll go ahead and have Jesse, if you want to send out the appeal when no notice amendment. And I'll go ahead and describe what it is as we get it pulled up. It's not overly wordy. The first part is on page 2, and the language is changed so that a appeal would only apply to cases where there was not a 30-day notice provided. And then it strikes E2 so that the facilities would not have to provide housing throughout the appeal process.
Do you want to make any other comments? I mean, I know technically that's what it does.
Yeah, so
but what are
the
you
reason-
intending?
The intent there, just from looking at the opponent testimony that we received and having real concerns about issues that could come up of housing individuals who they don't have staff capable of providing the care. That is the purpose of removing that part of the bill. The other issue is I do think, I understand we have regulations on the 30-day notice. I think that changing it to require that we allow an appeal on if the 30-day notice isn't received, that it incentivizes making sure that those conversations are taking place prior to the need to immediately lose your opportunity to have residency there, and hopefully those conversations will take place, understanding that there can still be issues outside of that as well. I would encourage further discussion.
Okay. Are there questions or is there discussion on the amendment? Representative Wagoner.
Yes, to the carry the amendment. So they would have 30 days that the resident who was, the problem would not be, they could move him someplace else until the appeal. I'm not quite following how that 30-day practically works in the sake of the assisted living facility and the resident who has the issues.
Representative Hoy.
Thank you, Madam Chair. Currently, the regulation requires the 30-day notice, and then we provide the exceptions for the safety of other individuals in the adult residential care facility would be endangered, or the resident's urgent medical needs require an immediate transfer to another healthcare facility. So those exceptions still exist, but those typically don't fall within the 30-day notice. So there could still be appeals for those issues, but any individual who received a 30-day notice would not be able to appeal.
Representative Vaughn.
Thank you, Madam Chair. I just wanted to clarify who the appeal process would go through. Is that the ombudsman, if I'm not mistaken?
Jesse, would you walk through that process, please, if that's okay with the chair?
Yes, please, Jesse.
Yes, definitely. Let me double check that. It looks like that the appeal of the transfer or discharge would go to the Secretary of KDADS, and then they would follow the Administrative Hearings Act, and that's how they would hold that hearing process.
Okay, thank you.
Further questions, discussion? Okay, seeing none, this will be a vote on the amendment. Representative Owsley has a question.
Thank you, Madam Chair. Being the first time I've seen this amendment, is this similar to the appellate process for the nursing homes?
Representative Hoy.
The what process? I'm sorry, I didn't understand.
Is this similar to, is there an appellate process for the nursing homes? To understand that there is, and that's the whole conflict here. Is this similar to that process? Do they have the 30-day waiting period also?
They have to provide the 30-day, but I don't know what their appeals process is. This is, because what the bill creates without this amendment is an appeal opportunity for any circumstance.
Okay. Thank you. Thank you, Madam Chair.
Any other discussion? Representative Penn.
Thank you, Madam Chair. Just for the full piece on line 40, where we're talking about, moving out of residence, I seem to remember part of the testimony being that some of these people were financially in distress and wouldn't be able to find other placement in the interregnum while the appeals process was going on. I wouldn't want someone to be, out on the streets if this particular amendment took place. Could you speak to that? How do we skin that cat, so to speak?
Representative Hoy.
Thank you, Madam Chair. Yeah, I think as the bill is without the amendment, it would prevent that, but if we amend it this way, there could still be some possibilities for that to occur.
You also have issues with CMS, what they are licensed to, the people that they are licensed to have there. It's a complicated issue, and it was difficult talking about this, that they would be removed, and then because that's the whole point, is that you You don't want to have to move somebody and then move them back. But, you know, if it's an appeal process, it's got to be an appeal process, so. Any other questions on the amendment? Representative Vaughn.
Thank you, Madam Chair. And I guess this may already be in statute since they have the 30-day requirement, but I am wondering, I think we're probably currently asking the assisted living facilities to provide any additional needed care that would be required to take care of that individual while they're still in residence. And I'm just wondering if that's correct. If I just, you know, like you're saying, I think it is complicated. I want to make sure that the individual is well cared for and that the other residents aren't in danger during that 30-day period either. So I'd just be curious in anyone's thoughts on that as well.
Well, and that is a good point. You know, I hate to bring anecdotal personal stories in, but my husband is the medical director of the geriatric psych unit. And this is exactly the type of situation that they will receive patients that have been a harm to themselves or others in a residential, in a assisted living facility, and they can't be controlled. And so they end up being admitted there. I mean, we've had quite a few discussions of this exact scenario. And so there are facilities that they can be moved to help with that situation. That are potentially a good place to be in the interim during an appeal. Other discussion? Representative Wagoner.
Of course, the amendment, of course, as you look at it, it's just kind of a wording change. I think you're trying to clarify the wording, as I'm seeing it, that I guess it seems if a resident of an adult residential care facility does not receive notice of a pending involuntary transfer, as required by this such section, would it, I mean, if they haven't received notice, then how are they aware? I mean, it seems like the original wording makes more sense. Do they receive notice that they're going to be transferred and then they file an appeal versus they don't receive any notice? I mean, I'm thinking I prefer the original wording versus your amendment.
Representative Hoy, do you want to explain that further?
Thank you, Madam Chair. I'll explain it and then ask if Jesse wants to add anything onto it. I asked to include language so that the only opportunity for an appeal is if the 30-day notice was not provided.
No, I'm thinking it through. So they're required to give a 30-day notice. And so someone is told that this facility can't handle your needs anymore. You know, 30 days from now, you need to have someplace else to live. So what the amendment says is if they walk in and say 2 or 3 days ahead, you've got 2 or 3 days to find someplace else to live, that's when they can appeal. If they've had their 30 days, what the amendment says, if they've had their 30 days, all the rules have been followed, then there's no option for the appeal. Representative Penn, did I see your hand up?
Oh, yes, Madam Chair. I was just walking through it as Representative Wagner was as well. And I guess I see what he's referring to. So just walk with me. If a resident of an adult residential care facility does not receive a notice of a pending involuntary transfer or discharge as required by this section, so you have no notice, this is what you're addressing right now, some of the testimony that we heard, which was quite horrific. And I agree with this, that you don't receive a notice, such resident's legal representative may appeal the transfer or the discharge, putting out on the street to the Secretary for Aging and Disability Services by filing a notice of appeal within 15 days. And then this part right here should probably be stricken after the date of such notice because they did not receive that notice up above. A presiding officer from the Office of Administrative Hearings should hold that hearing or shall hold that hearing in accordance with the provisions of the Kansas Administrative Procedure Act, and that is the 30-day time clock. That's where it starts from that no notice. So basically, you have 15 days once they come in and tell you, hey, you got to be out of here. 15 days later, you file your appeal, and that hearing must must occur within that 30 days of the receipt of that appeal. I think that's what you're saying right there. Is that correct, ma'am?
Representative Hoy?
Yes, but I'm not sure what you're suggesting needs to be changed.
Madam, just for my reading, where I guess is line 35, filing a notice of appeal, Office of Administrative Hearings within 15 days after the date of such notice. Up above, you said that they did not receive a notice. So I would to my mind, it's saying that the one is, leaning on the other.
Yeah, that may need some clarification because they'll still get they will still get notice that they're being asked to find new, I mean, they'll still receive some notice. It's just whether is the notice within the 30 days. So Jesse, I don't know if that needs to be clarified, but if they have to leave the facility, they're going to receive notice either 30 days or not.
So if it was a 3-day notice, can you ask that in the mic? That's all right.
Got on a mask and no mic. Lord have mercy. Thank you, Madam Chair. So by that understanding, Madam Chair, if you receive it, you get a 3-day notice. Hey, you need to be out of here in 3 days. Within 15 days, you can file your appeal within that window, right? And then that hearing must be held within 30 days from that notice of appeal. Is that correct?
I believe it is. Jesse, are you following us?
Yes, Madam Chair. So as we see in line 35, filing a notice of appeal, and then in line 36, that such notice is referencing that notice of appeal in line 35. Does that clear up
Yes.
which notice is which?
It does for me. Are you okay, Representative Penn? Okay. That was a thumbs up. Are there other questions? We're still on the amendment. Representative Penn.
Yes, Madam Chair. Just a quick question. Could we discuss the potential of this phenomenon to be a safety issue dealing with the resident? Does that, come into this more so, or I wish that we had some of the folk here and I had my notes from the testimony that we received. I'm just trying to see exactly what is it that pressures to have and arrive us at this situation that you would receive a no notice.
Do you know how to pull that up on your? Okay, so go to the legislative website, that homepage. Go to committees. Drop down to children and seniors. And then you want to drop down to bills still in committee and 100 or 2004. And then when you pull that up, then up above there you can see where I think it's in blue. It says testimony. And then you can drop down and choose which testimony. And there may be 2 or 3 pages listed there.
Thank you, Madam Chair.
Representative Vaughn.
Thank you, Madam Chair. And I had wondered the same thing as the previous representative, and I had found that list for the 30-day notice in section 1 of the bill as well. And had that provided some clarity for me, so I just wanted to share that. Thank you.
Representative Wagner.
Just again, in speaking regarding the amendment, I think the amendment, obviously is very well intentioned. I think it might help, but I would almost rather hear an amendment from like the assisted living people or something, or just as far as what would be, you know, given that the committee is pretty serious about this bill and see it as a real issue, that would they have something that would mollify sort of their concerns of being, you know, stuck with person who is, you know, has, you know, it's like a safety issue. I mean, there truly is kind of two sides to this story, and to kind of walk the line, I would tend to think that we would be maybe better off not amending it at this point and waiting until we had some more precise testimony from the people who are really going to intimately have to, you know, do this on a day-to-day basis.
Well, I just would say that we've provided a lot of time in this, and we do have their testimony, and they oppose the bill. So we haven't received any amendments or proposals. Representative Mosier.
Thank you, Madam Chairman. I will concur with what you just said, because I have had conversations with the parties that oppose this, and when asked what would you like to see to make this bill better, and I got a list of what they didn't like about it. Thank you, Madam Chairman.
You know, it's a difficult issue because there's nothing wrong with not liking it. You know, I think the whole concept leaves just exposes those facilities to some liability that you know, those of us who are not in the medical world don't understand. You know, what the expectations are and what the regulations are that they have to abide by. So that's where it makes our decision difficult. You know, it's there's things that pull at the heartstrings, and then there's regulations, and so it's a tough choice. Representative Hoy, did you have a comment?
I have a process question. Again, I'm glad we're just having this discussion and keeping this going, and wherever it ends up, I'm glad that we've done our due diligence on it. If this amendment would go on and we would pass it out, can motions be made from the House floor to refer it to certain, as we've discussed, like task force and things like that? Or is that something that would need to happen in committee?
It would need to happen in committee. It would, if that sort of is, if that's something we would wish to happen, it would be referred back to the committee for, you know, we can make an official recommendation that is sent to that task force, or, you know, it can just be something that the chair of the task force just decides to take up. You know, I don't need to have any official request from the committee to write a letter requesting the Judicial Council review the issue, but I am asking for the support of the committee today. That's why we're having the discussion. Representative Helmer.
I want to encourage you to do this. I feel like there would be no wasted time doing this. Coming from being a counselor in a school year for years, I took so many kids to assisted care homes, and they are I want to say almost deregulated at a lot of times, and I think that anything that we can do, I shouldn't say deregulated. I want to say a lot of times they're not up to what we think they are, or we wouldn't want to leave our parents in them. And I still get a lot of calls for them. So I think anything we can do at this point for Charlie's Law is going to help anything. any assisted living homes that we have. So I appreciate it, and I appreciate all the work that all of you put in on this. Thank you. Thank you, Madam Chair.
Representative Esau.
Thank you, Madam Chair. I have two very different questions. The one had to do with the amendment, and I just want to make sure I understand. If they are given 30 days notice, they can't appeal at all?
Representative Hoy.
Correct, there's not an existing appeals process for these types of facilities, is my understanding. So if, Jesse, if there's a correction to that, please let us know.
Jesse.
Thank you, Madam Chair. Could Representative Esau state that question again for me?
Certainly, because I don't know that I said it well. If they are given 30 days notice, then they would have no right to appeal at all. And I realize right now they have no right to appeal, but if they're given 30 days notice, or if they're given less than 30 days notice, they could appeal. So basically all we're doing is saying, if you don't give me enough time to find a better place, then I have the right to appeal. But as long as you give me enough time, you can say, hey, you got to move.
Yes, but that's not the only instance, Representative. So for example, the way it's currently written, it says receives notice in violation of this section. There are requirements that have to go into that notice. So if they were to receive a notice, that does not necessarily state the effective date or the reason for that, then they could appeal alleging that it's insufficient notice as required by the section. And this section gives them that ability to do so, whether or not they have given that 30 days as required.
Thank you. That was helpful. My other, and I'm not trying to stifle discussion here whatsoever, is I'm wondering if there's enough of us that are struggling with either what the amendment would do or what the amendment wouldn't do, if we would be better off asking to have another committee day so that we could consider action on a later date. And I realize that would mean tabling the bill. I'm not trying to make that motion at this point. I'm not.
Did I not give you enough time on this bill?
I did not study this bill prior to today and the day we heard the bill.
I'm just
some
teasing
of you
you.
did, and I greatly appreciate all the work y'all have put into it. I didn't know how much angst there was amongst the committee.
Yeah,
I'm not trying to.
I am just teasing you. With that, with that in mind, I will tell you that we are probably looking at a potential, and I don't plan to meet tomorrow, but we are looking at another potential committee day that we might be. It's not guaranteed, but that we may be allowed to have another committee day. So that would be an option of something that we could possibly take up. But we have an issue that's kind of going back and forth between the House and the Senate that we may have to come back in and deal with. Representative Penn.
Thank you so much, Madam Chair. And I'm trying to learn the process as well. I know I started this by saying that this was a very important issue and we should take it up, and I stand by that. And with the gentlelady's amendment, I think that is something that we really need some more time to understand the implications of it, because like the Vice, I haven't studied the bill since we first saw it. I do apologize for that. What I'm asking is if it's possible to have a motion to table this discussion and all things inside of it until a date certain, such as Monday, so that we have an opportunity to go back, check our notes, make some informed decisions, because what you said at the beginning, Madam Chair, it resonates well with me. These are our decisions to make, and I want to make the best one. I'm not averse to the bill. I'm not averse to the amendment. I just want to make sure that we make the right decision.
Tomorrow is the last day for committees on the House schedule. We could stay and meet tomorrow. You could make that motion to, but it would be up to a decision by the Speaker whether to allow the committee to meet. I think that's our options. Representative Smith.
Just asking, Madam Chair, thank you. The Nursing Home Association is against this bill? Did you say they were against it?
Not the nursing homes, just the assisted living facilities, leading age and.
And, you know, again, I've had some experience with both. And an assisted living facility, you know, there's times where they really can't handle the situation. And I knew a young lady that was working with a person that was very aggressive. And it turned out where the worker was arrested and taken to the county jail because of being too rough with her. And again, we put this on the facility and they can't do it. I mean, they can't. I'm a little bit concerned with.
Well, that's been, you know, what I've been torn with, because they don't have enough staff. They don't have the type of staff, the training. And we're talking about, you know, we've been talking about some aggression, but it also could be a medical issue. It could be a stroke. It could be someone that's declining and they don't have the ability to handle a medical situation. So, yeah, it all makes it even more complicated. And, you know, I agree that a little more time for everyone to be able to get the answers they would wish to have. I can't guarantee we'd have a committee time, though.
Madam Chair, if we canvass the committee, and I'm sorry, I didn't ask to be recognized. Do forgive.
Yeah, Representative Penn.
Yes, ma'am. If we canvass the committee and see if they're amenable to another meeting time next week to take this back up, if we have that opportunity, and we petition the chair, the speaker, would that be in order?
We could request it, but it's not. It's absolutely not our decision as far as that goes. But yeah, we don't. We would have to find a time in between, because we'll be on the floor all day.
Yes, ma'am. I'd be willing to go to bat for you. This is one of my favorite committees. It's actually one of the more bipartisan of the committee assignments that I received this first year, and I think you did good work in here. So I think that this is some legislation we need to think about.
I appreciate that. That's the way I like to run the committee. Thank you. Representative Smith.
Forgive me, Madam Chairman. This is a biggie. And, you know, the nursing home people were in here saying they're working 70 hours a week and they can't keep up. And then we throw this on them. I think even if we got to wait till next year to do it, I don't think I'm listening today, I don't think we're ready. I just don't think we're ready. Thank you.
Okay, we're in the middle of an amendment. Yeah. Oh, we didn't have, did we don't have a second to the amendment. So at this point, the amendment would fail for lack of a second. Yeah. So if we can get off the amendment, it failed for lack of a second, and I'd recognize Representative Hoy.
Thank you, Madam Chair. Again, I want to reiterate that I had strong feelings about keeping this discussion going. I could not support the bill as it is, sending it to the House floor like that. So I think this was an opportunity to keep it going. And if the committee wishes further study on it, I would yield to the committee. But I think we should do our best to move it along that's going to give it the best opportunity to resolve some of these issues. So I'm happy to yield to you if you want to vote on the amendment, or I would take your advice on that.
As far as the amendment, I just let it fail, for lack of a second, just to, and to get us back on discussion of the bill. So we're on discussion of the bill. Does anyone have any discussion on the bill? We do have an option that Representative Owsley just mentioned, that in the event that we don't have the senior care task force, that we have another option with the Bob Bethel Oversight Committee, that would be another opportunity to have some hearings on this. Let me just ask this. Is there anybody completely comfortable with passing this out today? I mean, just, I'm not taking, this is just a straw poll. I'm not, you don't have to answer, but if there is, okay, I'm seeing heads go like this. So with that, Representative Mosier.
Thank you, Madam Chairman. Is it possible to take all the pieces, the amendment notes and the bill, and put it towards the judicial review and have them look at all of it?
I think that's what they do. I think, but the nice part with that is that you've got legal eyes looking at it, and that's what we don't have. And they will look at the medical angle, and that's what we also don't have. And so procedurally, I don't know that we would. I think that we would could just adjourn the meeting, and I will make a request to I could make a request for each of the things for further information. Representative Penn.
Madam Chair, I believe that what's procedurally correct is that I have to withdraw my motion if it's amenable to the second.
Thank you. Yes, we did. We did have a second. I forgot we had that on the floor. So are you withdrawing your motion?
Madam Chair, I withdraw.
Madam Chair, I'm fine with that, and I thank the maker of the motion for doing so.
Okay, that motion is withdrawn, and if I would encourage you all to look at this bill, because I don't know when we might meet again, or what our next move is actually going to be. We are not going to meet tomorrow. And with that, we're adjourned.